I want to talk to you for a few minutes about how to do a proper setup. I'm going to tell you how I do it, and then I'll give you some suggestions for your situation. When I use the word setup, to me it has some negative connotations, so I want to make sure you know what we're talking about here. There are two kinds of a setup. One's good and one's bad. One setup, the negative one that I think may come to our minds first, is the idea of trying to trick someone or to make an offer that we don't really mean, to try to do something to set the other person up and to harm them. When I talk about setup, I'm talking about setting yourself up for success, putting yourself in the best situation to get the best possible outcome that you can get. So what that means for us is going to require a little bit of background and even telling you some things that you may assume and already know about what I do as a lawyer. In every kind of case I'm working on, if we file a motion or if there's an upcoming hearing, anyone involved in the case, any of the opposing parties and their attorneys, they're entitled to notice of that hearing. And it's not just a few minutes notice. They're entitled to advance notice, days, even weeks in advance of an upcoming hearing. If we file a motion, generally that notice means they should have plenty of time to be able to respond to our motion and tell the judge whether they agree or object to our motion and to get ready for a hearing. So that means more than just a few minutes or hours, even days. It means weeks. So I'm belaboring the point, but you get it. We have to give notice. When we file something, we're supposed to send a copy to the other attorney. In most cases, no big deal. Both sides are filing things, send them to the other attorney, responses are getting filed, and everybody's working up the case. However, there are scenarios where the opposing attorney will try to take advantage of the system to try to delay the case. There are a couple different reasons for that. One may be their client simply doesn't want to go to court. They have a bad case. Sometimes it just comes down to the lawyer's lazy and doesn't want to work on the case. There are a few different reasons why an attorney would do what I'm about to tell you that they'll do. But every once in a while, we'll file a motion, we'll mail it to the other side or even email it to them, and then we'll go to court, and that attorney will say, "Judge, I didn't know that was set today. I had no notice of today's hearing." They will say that and look me dead in the eyes and smile and dare me to prove otherwise. And a lot of times, even if I'm somewhat prepared for that, if I have a printout of the letter that we sent in closing the motion, or if I have a printout of the email, a lot of times the judge by default will just say, "All right, how much time do you need, counsel?" And they'll continue the hearing even when we need that hearing to get some relief for our client. Very frustrating experience. So if you are the opposing attorney and you do that to me, then you go on a special list. And we have built our system, we have created something that we call intentional redundancy, which means we are going to be able to prove that you knew about an upcoming hearing. And the way we do it, we are also signaling to you at the same time that we are doing this because we are eliminating in real time your ability to deny knowing about this hearing. So you better get ready for the hearing or come up with a different kind of strategy to put this off, because saying that you didn't know is not going to work. So one way we do that, we just started in everything that we file, we send a cover letter. Sometimes it's just one line. "Enclosed, please find our motion." And we will have a copy of that letter in our file to be able to demonstrate, hey, this is a matter of our process. We send a letter out. This letter is circumstantial evidence that the motion was sent to them. And we'll also send filings by email, whether the other attorney wants emails or not, just because we're doing something I call intentional redundancy. There's two types of redundancy, just like there are two types of setups. There's bad redundancy, where a lawyer is just doing things over and over again to run up a fee. And then there is intentional redundancy as part of our process to be able to cover up our actions and be able to demonstrate, yes, we did do what we're supposed to do. We sent it to them. A lot of times, if you're on that list, when we file our motion, we don't necessarily have it set for hearing at the same time, so we'll get an order for hearing later. So when we file our motion, we will mail you a copy of the motion. And then when we get the order for hearing a few days later, we will write another cover letter enclosing the order for hearing and re-enclosing the motion that led to the hearing, just to eliminate your ability to claim, I didn't know what this hearing was for. We have now sent you the motion twice, probably 3 times, including email. And if you're on our list, then you also get a fax with those things. And we're going to have a fax cover sheet showing that in addition to cover letters, emails, and faxes, we've done everything that we can. We'll do in-person delivery. We will take a copy and drop it off at your office. And a lot of times in that situation, if you're on that level of our list where you deny receiving faxes, mail, and email, then we will bring a receipt to your office for you or your assistant to sign the receipt acknowledging receipt of the motion or order for hearing or whatever it is that we're bringing to you. If that's happening to you, if that's coming to you from our office, then you are on a very naughty list and you have played games that have caused delay and that have cost our clients a great deal of expense in preparing for a hearing that wasn't going to happen just because you were playing games. So, to anyone else watching this video, you get the idea, right? Where we are just going to be able to prove independently that we have sent this information to you. Now, what does this mean for a client, somebody who's going through the legal process? Unfortunately, what I see a lot are some people taking things for granted. They take it for granted that if they say, Judge, he hasn't reimbursed me for the child-related expenses, that the judge will take your word for it. And unfortunately, the judge will not take your word for it. And so you've got a lot of child support obligors. And what I'm saying applies to beyond just child support. I'm using child support as an example. But you've got a lot of child support obligors who are going to take advantage of you taking things for granted because they know either consciously or subconsciously that you haven't done your due diligence and aren't able to fully show beyond a shadow of a doubt, and that's the standard for all cases, regardless of what the law says. You need to be able to prove beyond a shadow of a doubt that they knew about the expense, they know their percentage of it, and they're just refusing to pay. How do you do that? How do you do that before you even get to our office? Well, you wear them out with the information. When you get the invoice or you get the receipt, you send it to the other side. The fastest way to do that is by taking a picture of it. Now, I get a lot of information sent to me by somebody taking a picture with their cell phone. And not everybody has the latest and greatest Samsung or iPhone, I know that. But pictures can be really bad if they're not laid out flat, if the document's not laid out flat and well lit. If you send in a picture of a wadded up piece of paper with a lot of shading or no lighting at all, you may as well not even be going through this process, okay? It's a waste of time because anybody else looking at that is not gonna be able to know what it is. And so what you're doing, if you don't go through this process, is you're giving the other side deniability. Judge, I don't trust her at all, and she sent me this gray blob in a photo and said I owed $700, but I'm sorry, I couldn't read what it was, so yes, I didn't pay, and they're gonna get a pass because you took a shortcut, you took it for granted and just didn't send them a good picture. Now, picture's probably not enough. So send them that picture by text, a clean picture of the invoice or receipt. Tell them what their percentage is. Your percentage is X, so you owe $700 for this child-related expense. Then use one of the many free pieces of software, those applications out there for your phone that will convert your picture into a PDF, and you email them the exact same information. Send them an email and say, I sent this to you by text previously. This is a copy of the invoice. You've got to overkill this information. From Dr. X, your percentage is X, so you owe $700. And then, even after you've done that, same day, you've sent them a photo and you've sent them an email with a PDF attached. You got to follow up and you got to give them time. The next day is probably too soon. 2 days later is probably too soon. 3 days, maybe. But 4 days, 5 days, and then a week, follow up. Hey, I just wanted to follow up with you. I haven't heard from you about the invoice that I sent. And not only are you following up, resend it. Resend it by text and resend it by email. And then what I'll do, if you come to me in that situation and you say, look, I've got a mountain of bills. This guy owes me $10,000. And I have done everything that you said in your video about sending pictures by email and by text. And I also mailed this stuff to him. And I also gave him the doctor's office so he could call and get independent verification of this expense. And he has not paid me anything. He has not reimbursed me for these expenses. And this is his percentage that he owes. What I'll do before I file, I will generally get a copy of all those receipts. I will organize them like I'm getting ready for trial to create exhibits. And then I will send a demand letter to your ex, to that opposing party, with all the receipts and invoices. And I will say, pursuant to the last order, and I will enclose a copy of that order, your percentage of payment of these expenses is this amount, and you owe this amount within this amount of days. And in that situation, it is a setup for us for success. But a lot of times my client will say, hey, I've already sent that to him. Why are we doing this? I just want to charge him with contempt. What I want to do is I want to overkill this setup as much as possible. And that way, when we go to court, we mean business. And what I mean by meaning business is when we go to court and you haven't paid these bills and we can prove that you knew about them and you have just not paid, we are going to ask the judge to suspend your driver's license. We are going to ask the judge to let you sit in jail and think about this. We are going to garnish your wages. We are going to do everything possible because you now are the game player, and we have shown beyond a shadow of a doubt that you knew about these bills and that you didn't respond. You did not fulfill your duty as a parent and as an obligor to pay this child-related expense. The only way we get there is by the setup. If you try to shortcut that setup, then you will find yourself in a situation in discovery, in a contempt, where the other side has some level of deniability and they are still playing games. I mean, we may know in our minds that they knew about the expense, but they're playing games. They're saying they couldn't read it. They didn't get the information, just like the lawyers I deal with who, when I send them a motion, suddenly the mail stops being delivered to their office. Their email doesn't work. Their fax machine is down. And if you don't overkill it, then you'll be very frustrated. And you can actually increase your expenses paying a lawyer to reprove what you could have done on your own. And you know what I'm talking about. You know who we're dealing with. A lot of times when these people come to my office and the other side is not doing what they're supposed to do. Again, this goes beyond child support. You know the kind of person that you're dealing with. And so you understand when you're watching this, why we're doing what we're doing. With the lawyers that we deal with, it's very frustrating. And there is a level of expense. It's onerous. What I'm suggesting you to do is to go above and beyond what you're required to do. And that's what we do when those lawyers get on our list. And we are now in cover them up mode, bury them with proof. It is because we are setting them up. It is because ultimately what we want is bigger than that. We're putting our ego aside and we're saying when we go to court, we are going to show everything. Not only that this expense is real, but you owe it and you knew about it and you just refused to pay. So I said a lot to say this, that process, that setup applies in a number of scenarios. It goes beyond what I could even imagine, but there is a lot of value in creating a process with intentional redundancy, because when you get to court, you want to show the judge you did not take anything for granted. You proved it up, and now we're in court, we're ready. We don't need additional delay. We did all our work on the front end. What you'll find by doing that level of work and effort in the front end, even though it's frustrating, and even though it may have some expense associated with sending it and resending it and then having a lawyer resend what you've already sent, it will ultimately save you money. It's cheaper to do that on the front end than it is during the litigation process, because you're just dealing with more bodies and eyes looking at the documents, and there's more expense involved. And you can actually shorten the length and duration of your case because you've done so much work on the front end. There's so little left to discover in the discovery process. You can say, Judge, here's the bills, here's proof that he's received them. We need a trial. We need a trial, and we need notice to this person that their liberty is in jeopardy. We mean business about taking their driver's license and about sending them to jail, about getting all the relief that's necessary to get them to do what they were supposed to do.